I want to tell you something before I tell you anything else, because if I do not say it at the start you will spend the first part of this story waiting for me to explain myself, and I would rather you understand me before you judge me. I am not a quiet woman by nature. I have never been passive. I have never been the kind of person who sits in a meeting and accepts the outcome without knowing whether the outcome is legally sound. I spent 17 years practicing real property law in this state, and the one thing 17 years of real property law teaches you is that silence is not submission. Silence, when deployed correctly, is the most powerful position you can occupy in any room where someone believes you have nothing to say. I was silent about owning that house for 15 years because it was easier. I want you to know that. It was not wisdom. It was not strategy, not at first. At first, it was simply the exhaustion of a woman who had already fought one enormous fight to get that house back, and who did not have the energy left to also fight the family conversation about what it meant that she now owned it. My family had a way of turning good news into a grievance if the good news happened to belong to someone who was not them. My name is Vera Sutton. I am 46 years old. I am a licensed attorney in the state of Georgia, specializing in real property, deed law, and residential title disputes. I have handled over 200 unlawful detainer actions in the course of my career, which means I have stood in front of more judges than I can count and argued on behalf of property owners whose rights had been ignored, misunderstood, or deliberately violated. I never imagined I would one day stand in front of a judge and argue on behalf of myself. My mother's name was Harriet Sutton. She raised 3 children in a 4-bedroom house in a quiet part of Decatur that she and my father had bought in 1978 for a price that sounds impossible now, back when the neighborhood was ordinary and the oak trees in the backyard were still young enough to climb. My father died when I was 22, my sister Deanna was 19, and my brother Keith was 17. He left nothing except the house, a modest life insurance policy that covered the funeral and 6 months of bills, and a family that had never once discussed what would happen when he was gone. My mother held the house for 11 years after my father died. She worked as a school administrator, she kept the yard, she maintained the relationships with the neighbors, and she raised Keith through high school and into his first job. Then the year Keith turned 28, my mother was diagnosed with early-onset Parkinson's disease, and the family that had been scattered across different apartments and different sections of the city suddenly had a reason to care very much about the Decatur house. Nobody said it out loud. Nobody needed to. I understood the grammar of what was happening even before anyone asked me a direct question. My mother's illness meant her ability to pay the mortgage was uncertain. Her illness meant the house was now a variable in a conversation that people were already having in their heads without me. I was the oldest. I was the one with the law degree. I was the one, it was understood by everyone without discussion, who would figure it out. What I figured out, in the winter of that year, was that the mortgage was 3 months behind. My mother had not told anyone. She was embarrassed, or she was hoping the situation would resolve itself the way she had always believed difficult things would eventually resolve themselves if you kept your faith. I found the notices when I came to help her organize her documents for a medical appointment, 3 envelopes from the lender stacked neatly on the corner of her kitchen counter as though neatness would neutralize what was inside them. I paid the arrears myself. I paid them without telling Deanna or Keith, because I already knew what would happen if I told them. Deanna would have opinions about what I should do differently. Keith would have feelings about not having been asked to contribute. There would be a conversation that became an argument that became a grudge, and at the end of it the mortgage would still be 3 months behind and I would have spent a weekend managing the feelings of 2 people who were not the ones making the payments. I paid the arrears and I said nothing. Over the following 18 months, as my mother's condition made it increasingly difficult for her to manage her own finances, I took over the mortgage entirely. I did this through a formal legal process, because I am an attorney and I do not manage important assets informally. I worked with my mother's primary care physician to establish a letter of medical necessity. I worked with a financial power of attorney to consolidate the household accounts. And then, in a process that took 4 months and required my mother's informed and documented consent, I refinanced the mortgage into my own name and became the titled owner of the property. My mother understood what she was signing. I want to be clear about that. She was not diminished at that point. She was slower and she tired easily and sometimes she lost words in the middle of sentences, but her cognition was intact and her judgment was sound and she sat at the kitchen table and read every document I gave her and she asked questions and I answered them and she signed where I pointed. She said, "Vera, does this mean the house will be safe?" I said, "Yes, Mama. The house will be safe." She said, "That is all I care about." She did not say anything about Deanna. She did not say anything about Keith. I noticed that. I noticed she did not say make sure your brother and sister have a place to go. She said the house will be safe, and that was where she stopped. I thought about that later, after everything happened. I think she understood something about her children that I was still being generous about. I did not tell Deanna or Keith that I now owned the house. I want to sit with that for a moment, because I know how it sounds. I know that a reasonable person could argue I should have disclosed it. I know that a reasonable person could say that owning a family home and not telling the family is the kind of secret that turns into something ugly over time. I have given myself that argument many times in the 15 years since I refinanced that mortgage. I am giving it to you now so you can see that I have not avoided the question. The honest answer is this: I did not tell them because I did not want to have the conversation. I did not want Deanna to tell me that the house should be held jointly and that what I had done was selfish. I did not want Keith to ask me what would happen to his share. There was no share. There had never been a share. There was a mortgage that nobody else was paying, a parent that nobody else was managing, and a deed that reflected the legal and financial reality of whose name had been on those payments for 18 months. The deed was accurate. The deed told the truth. I had simply chosen not to announce the truth, because the announcement would have cost me more than I had left to spend. So I stayed quiet. My mother lived in that house for another 4 years. I helped manage her care from across town, coming twice a week, coordinating with her home health aide, keeping the utilities current and the property taxes paid. Deanna visited on holidays and sometimes in between. Keith visited when he was between situations, which was his way of describing the intervals between jobs and relationships that marked his adult life. Neither of them asked who was paying the mortgage. Neither of them asked whose name was on the deed. They ate at the kitchen table and they watched television in the living room and they said goodbye at the end of their visits and they did not ask. My mother passed on a Thursday morning in April, 7 years ago now. She died in her own bedroom in her own house, which was what she had wanted, and the home health aide who was with her called me first, which told me something about the hierarchy that had been established in that house without anyone needing to say it. I handled the estate. There was no will, which made things more complicated, but the complication was manageable because the primary asset, the house, was already titled in my name and therefore not subject to probate distribution. My mother's personal property was modest. There were accounts with small balances. There were items of sentimental value. I distributed what I could between Deanna and Keith with the patience of a woman who understood that grief makes people unreasonable, and I did not fight about the things that were not worth fighting about. Nobody asked about the deed. I think Deanna assumed the house would eventually be sold and the proceeds divided. I think Keith assumed the same thing, or he assumed that the house would be dealt with at some point in the future by someone else, which was how Keith had always related to most problems. And because neither of them asked, and because I was not going to volunteer the information under circumstances that were already emotionally charged, the question of the deed drifted into a quiet part of the family understanding where things go when no one wants to name them. I continued paying the property taxes. I continued paying for maintenance. I rented the house to a tenant for 3 years, a retired schoolteacher named Francis who kept the yard beautifully and paid on the first of every month without exception. When Frances moved to be closer to her daughter in North Carolina, I began the process of deciding whether to sell or rent again. That was the period when my accident happened. It was February. I was driving home from a deposition on the east side of Atlanta on a night when the temperature dropped fast enough to turn standing water to ice on the bridges, And the car behind me on I-20 did not understand that the bridge surface was different from the road surface, and I understood it too late myself. The impact was lateral. My car crossed 2 lanes before the barrier stopped it. I remember the sound of it, and then I remember nothing until I was in the emergency room and a nurse was asking me if I knew what year it was. I had a fractured collarbone. I had 2 cracked ribs. I had a concussion that the neurologist described as serious and the attending physician described as serious with additional emphasis. I was kept in the hospital for observation for 5 days and then transferred to a rehabilitation facility for 16 days of supervised recovery. I was not in a position to manage anything during that time. My phone was in the car and the car was a total loss, and it took 3 days for my firm's paralegal to track down the right hospital to call. I was in the rehabilitation facility for 16 days. My sister moved into the house on day 11. I did not know this until I was discharged. I did not know because I did not have consistent phone access and because the people who knew how to reach me, my paralegal, my assistant, my closest friend Patricia Lamb, were focused on my medical situation and did not know they needed to be watching a property in Decatur. I did not know because nobody told me, which is not the same as nobody knowing. Keith knew. He told me later, much later, when things had already gone to court, that Deanna had called him from the driveway on the day she moved in. He said she had told him the house was just sitting empty and someone needed to be in it, and he had said okay because that is what Keith says when he does not want to engage with what something actually means. Deanna had been living in a 2-bedroom apartment with her boyfriend Raymond and Raymond's 2 teenage children from his prior relationship. The apartment was crowded and Raymond's lease had not been renewed. I know now, though I did not know then, that they had been looking for somewhere to go for 6 weeks before my accident gave them what they apparently decided was an opportunity. She changed the locks on day 12. I found out about the lock change when I arrived at the house the day after my discharge, because I was still the owner of the property and still paying the insurance and still planning to list it with a realtor in the spring, and I drove there with my arm in a sling and my ribs still aching, and I put my key in the front door and the key did not turn. I stood on the porch of my mother's house with a key that no longer worked, and I understood immediately what had happened. Not because I am particularly intuitive, but because I am a real property attorney and I have seen this specific pattern more times than I can count. I have seen it in client files and court records, and I have sat across the table from people who did exactly what my sister had done and argued that their intentions were reasonable and their position was legitimate, and the person standing on the outside of the changed lock had no right to be there. I had never once, in 17 years of practice, imagined that I would be the person standing on the porch. I rang the doorbell. I waited. I heard movement inside, the sound of a television, the sound of a child running across the floor, the sound of ordinary domestic life being lived in a house where I was the legal titleholder and someone else had decided I was irrelevant. Deanna opened the door. She was wearing a robe. She looked at me with an expression I can only describe as the face of a person who has prepared what they are going to say and is now adjusting it in real time because reality is not matching the version they rehearsed. She said, "Vera, I heard you were in an accident." I said, "I was." She said, "We were worried." I said, "I can see that." She looked at the sling on my arm and then she looked at the key in my hand and she said, "We've been keeping an eye on the place. It didn't make sense to leave it empty." I said, "This is my house, Deanna." She looked at me for a long time. Then she said, "Mama's house." And I said, "No. My house. My name is on the deed." The expression on her face in that moment is something I have thought about many times since. It was not guilt. It was not surprise, exactly. It was something closer to recalculation, the face of a person who has been operating on an assumption and has just been told the assumption was wrong, and who is now, in real time, deciding whether to revise the assumption or contest the information. She chose to contest the information. She said, "I don't think that's right." And I said, "I know it is." She said, "We should talk about this." I said, "We will. But first you're going to give me the key to my house." She did not give me the key. She said she needed to talk to Raymond first. She said it wasn't a good time because the kids were home. She said she needed to understand the situation better before she made any decisions. She said this with the calm of a woman who had already decided that the conversation I was initiating was negotiable, that the ownership I was asserting was a position rather than a fact, that the deed I had referenced was something she could respond to rather than something she was required to obey. I drove home with my arm in a sling and my ribs aching and the key that no longer worked to my own front door sitting in the cup holder of a rental car. I called my office. I told my paralegal to pull the Decatur property file. And I started the clock. Because here is the thing my sister did not understand when she changed those locks. Here is the thing she did not understand when she told extended family that the house now belonged to her, which I discovered from 4 separate phone calls over the following week from cousins and aunts who were confused about why I would give my sister a house I had never mentioned owning. Here is the thing she did not understand when she enrolled Raymond's children in the local elementary school and listed the Decatur address as their home address and began, by every observable action, behaving as though the address was hers. She did not know what I did for a living. She knew I was a lawyer. She had always known that. But the specific nature of what I practiced, the precise set of tools my profession had given me, the exact knowledge that now sat between her assumption and the outcome she was planning for, that she did not know. She did not know that I had drafted more unlawful detainer petitions than I could count. She did not know that I had stood before the judges of the Fulton County Superior Court and the DeKalb County Superior Court and won property cases that looked, from the outside, considerably more complicated than this one. She did not know that the moment she changed those locks, she had crossed a legal threshold with a name and a procedure and a set of remedies that I knew with the precision of a person who had spent 17 years being paid to know them. She thought she was in a family dispute. She was in a property case. And she had handed it to the one person in the family with a law license. I want to say one more thing before I take you into what happened next. I want to say that I did not go into this wanting to destroy my sister. I know what this story looks like from the outside. I know there are people who will hear the facts and say she should have disclosed the deed years ago, and they are not entirely wrong. I know there are people who will say the family should have had a conversation, and they are not entirely wrong either. I have sat with the complicated truth of my own choices in this story many times. But I also want you to understand what it felt like to stand on the porch of a house I had bought and paid for and maintained for 15 years, with a broken collarbone and 2 cracked ribs, and have my sister look at me and say I don't think that's right. I want you to understand what it felt like to be a real property attorney standing on the outside of a lock change. I want you to understand that when Deanna made her decision, she was not making it in a vacuum. She was making it in a history. A history of assumptions about who I was and what I was owed and what the word family entitled a person to take. She was making it in a context of 15 years of silence that she had interpreted, incorrectly, as acquiescence. She was about to learn what the silence had actually been. The unlawful detainer process in Georgia is not complicated if you know it. It is designed to be efficient. The legislature built it that way because the alternative, a situation in which property owners must navigate a slow and murky process to recover possession of their own land, creates exactly the kind of instability that property markets cannot function under. The process has timelines. The process has notices. The process has specific forms and specific filings and a specific sequence of events that, if followed correctly, leads with legal inevitability to a particular outcome. I knew the process the way a surgeon knows an incision. I had walked other people through it so many times that the steps existed in my memory without effort, the way fluent speakers of a language do not need to translate before they speak. On the morning after Deanna refused to return my key, I sat at my desk in my home office with my arm still in its sling, and I drafted the demand letter. Georgia law requires a demand for possession before an unlawful detainer action can be filed. The demand must be in writing. It must clearly identify the property. It must clearly identify the person in possession. It must demand that the person vacate within a specified time period, and it must be delivered in a manner that creates a record of receipt. I have drafted hundreds of these letters. I have templates in my system going back 8 years, modified and refined each time I found a way to make the language more precise, more complete, more resistant to the kinds of arguments that a creative opposing counsel might try to build around ambiguity. The letter I drafted that morning was for my sister. I did not use a template. I wrote it from the beginning, which I had not done in years. I wrote it that way because I needed to feel every word of it. I needed to be the author of this document in a way that went beyond professional. The letter told Deanna in plain, unambiguous, legally precise language that she was in possession of a property titled solely to Vera Sutton, that her occupancy had not been authorized by the titleholder, that she had materially altered the property by changing the lock mechanisms without permission, and that she was required to vacate the premises and surrender possession within the statutory period or I would file an unlawful detainer action in the DeKalb County Superior Court. I sent it by certified mail with return receipt. I sent a copy by email with a read receipt request. I sent a third copy by personal delivery through a process server so that there would be no ambiguity about whether she received it. She received it on a Thursday. She called me that same evening. The call was brief and it was not productive. Deanna said the letter was an overreaction. She said I was being dramatic. She said she was family and the house was a family house and the deed situation was something that could be worked out without involving courts. She said Raymond's children were enrolled in school and moving them was going to be disruptive and I needed to think about the children. She said my mother would not have wanted this. I listened to everything she said. I did not interrupt. I have learned, over 17 years of practice, that people tell you a great deal about their position when they think they are making an argument. The way a person argues reveals what they believe their strongest ground to be. Deanna's argument was almost entirely emotional and logistical, which told me that she had either not consulted an attorney or had consulted one who had told her what her position actually was and she was choosing not to hear it. I said, Deanna, I need you to be out of the house by the date in the letter. She said, I'm not doing that. I said, I know. She said, so what are you going to do? I said, file the petition. She was quiet for a moment. Then she said, you wouldn't do that to family. I said, Deanna, you changed the locks on my property while I was in the hospital with a fractured collarbone. I am past the point of deciding what I would do to family. I filed the petition the following Monday. The DeKalb County Superior Court handles unlawful detainer actions on a dedicated docket. The clerk's office is efficient if you know how to prepare a filing correctly, which means having the deed certified, having the demand letter and its proof of delivery attached, having the petition formatted according to the court's local rules, and having the filing fee ready. I had all of these things. The clerk processed the filing in under 20 minutes. The case was assigned a number. A hearing date was set. The hearing date was 5 weeks out, which is standard. I went home and I called my firm's senior paralegal, a woman named Grace Tanner who had been with me for 9 years and who had the organizational instincts of a person who had been managing complex legal matters since long before she worked for me, and I asked her to set up a full property file for the Decatur address. Deed history, tax records, utility account history, mortgage payoff documentation, everything. I wanted the record to be so complete that there was no question in any judge's mind about what this property was, who had owned it, and for how long. Grace said, "This is your own house, isn't it?" I said, "Yes." She said, "Is this your family?" I said, "Yes." She was quiet for a moment. Then she said, "Okay, I'll have it ready by Thursday." That is the kind of paralegal Grace was. She did not press. She understood that I had already considered every dimension of what I was doing, and she was there to help me do it correctly. While Grace was building the property file, I was tracking down the information I needed about what had happened in the 16 days between my accident and my discharge. I wanted to understand the timeline not just emotionally, which I had already done and which had produced a complicated mixture of anger and grief that I was keeping in a separate compartment where it could not interfere with the work, but legally. I needed to know exactly what Deanna had done, in what order, and what record existed of each action. The lock change I already knew about directly. I had the documentation from a locksmith I hired to rekey the property after the hearing, assuming I prevailed, which I had already begun planning for even before the hearing was scheduled. What I did not yet know was the full extent of what she had represented to other people about the property. I found out over the following week. She had told my Aunt Cecilia, my mother's sister who lived in Marietta, that I had transferred the house to her. She had told Cecilia this directly. In a conversation Cecilia recounted to me with obvious discomfort because she had not known whether to believe it and had not known how to ask me about it without risking a conflict. Cecilia is 73 and has spent a lifetime avoiding conflict within the family, and I did not fault her for waiting to see what would happen. She had told Raymond's ex-wife, who shared custody of the teenage children and needed to know the children's address, that she now lived in a family home that belonged to her. She had said this in a text message that I later obtained in discovery, because Raymond's ex-wife became a peripheral figure in the case when the question of the children's enrollment arose and opposing counsel attempted to use the school enrollment as evidence of good faith residential establishment. She had told two neighbors, a couple named Frank and Carol Ellison who had known my mother for 30 years and who still had my phone number from when I used to call them to check on my mother during the years she was ill. The Ellisons called me 3 days after I filed the petition. Frank said, "Vera, Deanna told us she was going to be staying at the house now." He said it carefully, the way people say things when they suspect the story they have been told is incomplete. I said, "Frank, I appreciate the call." He said, "She also said you gave it to her to help with the housing situation." I said, "Frank, I did not give anyone anything." He was quiet and then he said, "That is what we thought." I am telling you all of this because I want you to understand what Deanna was doing. She was not simply taking advantage of an empty house. She was building a narrative. She was creating, in the family and neighborhood network around that property, a version of events in which the transfer of the house was voluntary, consensual, and complete. She was doing this while I was in a rehabilitation facility. She was doing this while I was receiving occupational therapy for a fractured collarbone. She was doing this methodically and without hesitation, which suggested that this was not an impulsive act taken advantage of a temporary situation, but a plan that had been forming for some time and for which my hospitalization had simply been the precipitating event. This mattered to me professionally because it bore on the question of intent, and intent matters in unlawful detainer actions when the occupying party attempts to establish a good faith claim to possession. A person who genuinely believed they had been given permission to occupy a property behaves differently from a person who knows they have not. The narrative Deanna was constructing around the property, the active misrepresentation to multiple third parties, was not the behavior of someone acting in good faith. It was the behavior of someone who understood that what they were doing was not authorized and was working to construct a record that would make it harder to establish that. She did not understand that I could read that record. She did not understand that I had been reading records like that for 17 years. On the day before the hearing, my paralegal Grace delivered the complete property file to my office and I reviewed it in full. The file contained the original purchase deed from 1978 in my parents' names. It contained the 2003 deed transfer after my father's death and the subsequent filing. It contained the 2008 refinancing documents transferring the mortgage and title to Vera Sutton. It contained 15 years of property tax records in my name. It contained the title insurance policy. It contained the current mortgage payoff documentation showing the property was free and clear. It contained the certified current deed showing no liens, no encumbrances, no other interests of any kind. The deed was clean. The record was complete. The chain of title was unambiguous. I reviewed every page. I had Grace highlight the key dates and put the key documents in chronological order for easy reference during the hearing. I made notes. I prepared the direct examination I intended to conduct on myself, which you are permitted to do in Georgia in an unlawful detainer proceeding when you are representing yourself, which I was, because I am a licensed attorney and I knew exactly what I was doing and I did not need to bring a colleague into a case that was this clean. Deanna had retained an attorney. I found out 2 weeks before the hearing when opposing counsel filed an entry of appearance and a brief in opposition. The attorney's name was Gareth Hollins. He had been practicing family law and real estate matters for 11 years, which I knew because I looked him up. His brief argued three things: that the property had long been treated as a family asset and the formal deed did not reflect the true nature of the ownership arrangement, that Deanna had moved in with a reasonable belief based on family communications that the property was available for family use, and that removing her and Raymond's children from the property would cause undue hardship to minor children who were enrolled in school. The brief was not frivolous. It raised the kinds of arguments that attorneys raise when the legal position is weak but the factual and equitable narrative might create some sympathy. Gareth Hollins understood that he could not win on the deed. The deed was absolute. He was trying to get a judge to slow things down on equitable grounds, or to create enough ambiguity about the family communications that a factual dispute might emerge. I read the brief twice. Then I drafted my response. The response addressed each argument in turn. On the family asset theory, there is no legal instrument, no trust document, no joint ownership agreement, no written or recorded arrangement of any kind that establishes any interest in this property other than that of the sole titleholder. The property tax records, the insurance records, the utility payment history, and the mortgage payoff records all reflect a single owner. A family's informal understanding of how an asset is used does not create a legal interest in that asset. On the good faith belief argument, Deanna's communications with third parties in the days following her entry onto the property demonstrate not a good faith belief in her right to occupy but an active misrepresentation of the circumstances of that occupation, including representations to family members and neighbors that the property had been transferred to her voluntarily. On the hardship to children, the law does not recognize a right to occupy property because one's dependent has enrolled in a nearby school. The hardship, if any, was created by Deanna's decision to occupy the property without authorization, not by the titleholder's enforcement of her rights. I filed the response. Then I waited for the hearing. During the waiting period I had 3 phone calls from family members. My cousin Leon, who was close to Deanna, called to ask if there was a way to resolve the situation without court. I said there was, and it had been in the demand letter I sent 5 weeks ago, and the time for that resolution had passed. My Aunt Cecilia called to say she hoped we could work it out. I told her I appreciated her calling and I loved her. Keith called to say he thought I was being harsh and asked if I could give Deanna more time. I said, "Keith, did you know she moved in?" He was quiet. I said, "She called you from the driveway." He said, "She said she was just going to stay for a few weeks." I said, "She enrolled children in the school district and told our aunt I gave her the house." He was quiet again. I said, "This was not an impulse, Keith. You understand that?" He said, "Yeah." He said it the way people say yeah when they are starting to understand something they did not want to understand. I said, "I'm going to the hearing. The date is set. I'll see you after." He said okay. I went to the hearing. The courtroom where unlawful detainer hearings are conducted in DeKalb County is smaller than the main trial courtrooms. It has a specific energy, the energy of a room that sees disputes that are personal in a way that other legal matters often are not. Property cases involving family members have a particular quality, a grief underneath the argument that the legal framework does not account for but that sits in the room regardless. I arrived early. I always arrive early. I set up my materials at the plaintiff's table, which is what I am when I am the one who filed the petition. Plaintiff. I arranged the property file in the order I intended to reference it. I placed the certified deed on top, because the deed was the first thing I wanted the judge to see, and the judge seeing the deed early was the most efficient path to the outcome I was there to achieve. Deanna arrived with Gareth Hollins 12 minutes before the hearing started. Raymond was with her. I had not expected Raymond. He is a quiet man, physically large, with the specific stillness of a person who has been in enough difficult situations to understand that adding energy to them rarely helps. He looked at me when he came in and then he looked at the floor and then he sat down in the gallery row behind the defense table. Deanna did not look at me when she came in. Gareth Hollins looked at me immediately. He assessed the materials at my table the way attorneys assess each other's preparation before a hearing starts. I have been on both sides of that assessment. I understand what he saw when he looked at the volume of the property file, at the organization of the documents, at the specific posture of a litigant who is not nervous because she already knows how this ends. He leaned over to Deanna and said something I could not hear. The judge was a woman named Honoria Stafford, who had been on the DeKalb County Superior Court bench for 14 years. I had appeared before her twice in prior matters. She was precise, she was efficient, she was patient up to the point where patience was no longer serving the proceeding, and she was not interested in arguments that were not grounded in the relevant legal standards. She was, in short, exactly the judge you want when you are on the right side of a clean property case. Judge Stafford called the case. She asked both parties to identify themselves for the record. I stated my name and said I was a licensed Georgia attorney appearing pro se. She noted that in the record without comment, which in my experience means that the judge is now more alert to the quality of the arguments she is about to hear, because a pro se attorney in her own case is either very confident or very foolish, and the record in front of her was organized in a way that suggested the former. Gareth Hollins identified himself and Deanna for the record. Judge Stafford said, "This is an unlawful detainer proceeding. The question before the court is whether the defendant is in possession of real property belonging to the plaintiff without legal authority." She said it the way judges say things they have said many times, with the efficiency of a person who knows the terrain. I presented my case. The first document I introduced was the certified current deed. I submitted it into evidence and asked the court's permission to publish it for the judge's review. Judge Stafford looked at it. She looked at the title holder's name. She looked at the recording date. She set it down and looked at me and said, "Miss Sutton, this is the controlling document." I said, "Yes, Your Honor, it is." I then introduced the 2008 refinancing records showing the transfer of title. I introduced the property tax records for 15 years. I introduced the insurance documentation. I introduced the certified letter and the proof of receipt establishing that the demand for possession had been properly served. I introduced the evidence from the locksmith that the lock had been changed by someone other than me after the date of the demand letter. Judge Stafford reviewed each document as I presented it. She did not interrupt. Then I spoke to the misrepresentation issue, which I had raised in my written response but wanted to address directly in the proceeding. I offered into evidence the texts from Raymond's ex-wife in which Deanna had represented that she lived in a property that belonged to her. I offered the testimony of Frank Ellison, who had submitted a short written statement at my request describing the conversation in which Deanna had told him the house had been given to her. I said to the judge, "This is not a case in which someone made an honest mistake about her right to occupy a property. This is a case in which the occupant actively and repeatedly misrepresented the nature of her possession to third parties." Judge Stafford looked at the exhibits. Then it was Gareth Hollins' turn. He made his arguments with the skill of an attorney who knows his position is disadvantaged and is working to find the ground that is not already covered. He argued that the family history of the property was relevant to understanding the equities. He argued that the deed did not tell the whole story. He argued that his client had moved in under the reasonable belief that the property was available for family use. He argued, carefully, about the school enrollment of the children. Judge Stafford let him finish. Then she said, "Counselor, does your client have any legal document evidencing an interest in this property? Any transfer, any trust instrument, any recorded agreement of any kind?" Hollins said no. She said, "Does your client have any written communication from the plaintiff authorizing her to occupy the property?" He said no. She said, "Does your client have any evidence that the plaintiff was aware she was in the property before the plaintiff arrived on her doorstep after discharge from a rehabilitation facility?" He said, "The family's long-standing relationship with the property." Judge Stafford said, "Counselor, I understand the equities you're presenting. I am asking about legal instruments." He said no. Judge Stafford picked up the certified deed. She held it in a way that told me she had made her decision before Gareth Hollins finished his argument, probably before he started, and was now completing the procedural requirements of the hearing before delivering an outcome that had been visible from the moment I submitted the property file. She said, the plaintiff holds a current, certified, unencumbered deed to the property at this address. There is no legal instrument of any kind in the record establishing any interest in this property on the part of the defendant. The defendant's occupancy was not authorized by the titleholder. The defendant received proper notice demanding possession and declined to comply. This is an unlawful detainer. She looked at Deanna directly, the way judges look at parties when they want to make sure the human being in front of them understands what is about to happen. She said, Miss Sutton, the court is issuing a writ of possession in favor of the plaintiff. You will have 7 days to vacate the property and remove your personal belongings. If you have not vacated within 7 days, the county marshal's office will execute the writ. Deanna made a sound. Not a word, just a sound, the sound of a person who had genuinely believed, up until this moment, that the outcome was not going to be what it was. Gareth Holland said, Your Honor, we would request additional time given the children in the household. Judge Stafford said, 7 days is the statutory period, Counselor. The court will not extend it. She signed the order. She handed it to the clerk. She called the next case. I stayed at the plaintiff's table long enough to collect my materials into the file in the correct order, which I do out of habit. I was aware of Deanna behind me. I was aware of Raymond standing up from the gallery. I was aware of Gareth Holland speaking quietly to Deanna and her responses to him. When I had my file organized, I stood and I picked up my bag and I walked out of the courtroom. In the hallway, I stopped by a window that looked out over the parking lot. It was a gray March morning. The trees were starting to come back. I stood there for a moment with my hand on the window frame, and I thought about my mother at the kitchen table, reading the refinancing documents, asking me if the house would be safe. Yes, Mama. The house will be safe. I thought about what safe had cost. Then I walked to my car. The 7 days after the hearing were the strangest 7 days of the entire situation, and I say that understanding that the entire situation had already contained some very strange days. Deanna called me the evening after the hearing. Raymond had taken the children to his former apartment, which he had apparently maintained on a month-to-month basis during the period they were staying at the Decatur house. I learned this detail from Raymond directly, 6 weeks later, when he contacted me separately and apologized in a way that was specific and that I found I believed. He said he had told Deanna before she moved in that he did not think it was a good idea. He said she had told him the house was the family's and she had as much right to it as anyone. He said he had accepted that because the alternative was a fight he was too tired to have, and that he understood now that the thing he had been too tired to have would have been considerably less costly than the thing that actually happened. I thanked him for saying that. I did not tell him it changed anything, because it did not change anything in a legal sense. But I believed him, and I appreciated that he had found the words to say it. Deanna's phone call the evening after the hearing was not like Raymond's call 6 weeks later. Her call was not an apology. Her call was a recitation of grievance. She said I had always thought I was better than the rest of the family because I had a law degree. She said I had used the legal system as a weapon against her. She said our mother would be ashamed of me. She said I had never shared anything with the family, that I had always kept everything for myself, that the house was simply the most recent example of a pattern that had been going on since we were children. I listened to all of it. I had learned long ago that Deanna's grievances, when delivered in this register, were not requests for response. They were declarations. They were the monologue of a person who needs to build the narrative in which they are the wronged party before they can close the distance between what they did and what they believe about themselves. I said, Deanna, you have 7 days. She said, I know. I said, I'm not going to extend that. She was quiet for a moment. Then she said, I need to know what you're going to do with the house. I said, that is not your question to ask right now. She said, will you sell it? I said, I don't know yet. She said, if you sell it, will any of that go to the family? And I understood then, sitting in my kitchen with the phone to my ear, the thing that had been true the whole time and that I had been too close to the situation to see clearly before this moment. This was never about a place to live. Raymond had the apartment. they had options. This was about the money. The house in Decatur, at current market values, was worth considerably more than my parents had paid for it in 1978. The neighborhood had changed. The property values had risen. The house was free and clear. The number it would sell for was the kind of number that Deanna, who had been in financial difficulty for most of her adult life, had looked at and decided was too large to be owned by only one person. She had not moved in because she needed a roof. She had moved in because she needed the money that the roof represented, and she had calculated, incorrectly, that if she could establish occupancy long enough and deeply enough, something would break in her favor. She had not understood that nothing would break. Not because I am without compassion, but because property law does not have a mechanism for breaking in the direction of occupants who have no legal interest in a property. The system is designed to protect owners. I am an owner. The system protected me. I said, Deanna, I need you to focus on the 7 days. She hung up. She vacated on day 6. I know because I drove past the house in the early evening and the lights were off and the driveway was empty. I did not stop. I drove past and I went home. The following morning I called a locksmith to rekey the house, which I had scheduled in advance. I walked through the property to assess the condition. They had not damaged anything, which surprised me less than it might have surprised someone who had not spent 17 years watching how people behave when they know a record is being made. By the time Deanna understood the hearing outcome was real, she also understood that anything she did to the property would become part of a legal record, and she is not a foolish person. She is a person who made a very large miscalculation, but she is not foolish. The house was in reasonable condition. The yard needed attention. The refrigerator had things in it that were not mine. I dealt with it. Then I sat at the kitchen table, the same table where my mother had signed the refinancing documents, and I let myself feel the thing I had been keeping in the compartment for 8 weeks. It was grief, mostly. Grief for the version of my sister I had believed in for a long time, the version that had not moved into my house while I was in the hospital and told our neighbors she owned it. Grief for the family conversation we had never had, the one in which someone might have asked who actually owned this house and what should happen to it and what was fair. Grief for my mother, who had sat at this table and said the house will be safe and had not said what she seemed to know about her children. There was also something else under the grief, something that took me longer to name. It was a kind of release. I had been carrying the quiet of that deed for 15 years, the decision not to announce it, the management of other people's assumptions, the patience of a person who owns a thing and has never said so out loud because the saying felt like more than she had energy for. That quiet had weighed something. I had not understood how much it weighed until it was over and the weight was gone. The extended family found out what had actually happened in the way families always find out things, in pieces and sequences and versions that differ depending on who told whom and in what order. My Aunt Cecilia called me 3 days after I rekeyed the house. She said she had heard things had gone to court. I said yes. She said she had heard the house was mine and had been mine for a long time. I said yes. She was quiet and then she said, "You did a good thing with that house, Vera. Keeping it together like that." I said, "I tried, Cecilia." She said, "I know you did." Keith called on the 4th day. He said he had talked to Deanna. He did not say what she had said. I did not ask. He said, "She's upset." I said I understood that. He said, "She didn't know the deed was in your name." I said, "I know." He was quiet for a moment and then he said, "Were you going to tell her eventually?" I said, "I don't know, Keith." I had not gotten that far. He said, "Okay." He said it the way he says things when he is done with a conversation he did not want to be having. I let him go. I thought about telling eventually for a long time after that call. I thought about the shape of the conversation, the one I had not had 15 years ago, the one I had not had when my mother died, the one I had not had at any of the family dinners or holiday gatherings or phone calls in the years since. What would that conversation have looked like? What would have changed? I do not think Deanna would have accepted the reality of the deed with grace. I think she would have contested it, not legally, but emotionally and persistently, in the way she contests things that do not match the version of reality she has decided is accurate. I think she would have said it was unfair. I think she might have said it should be shared. And I think I would have had to say no, and then we would have had the rupture we eventually had anyway, only we would have had it 15 years ago while I was still paying the mortgage and managing my mother's care and practicing law full-time, which is to say at a moment when I had even fewer resources to spend on it than I had now. I am not saying the silence was right. I am saying I understand it. What I want you to hear, in this part of the story, is not the court hearing. The court hearing went exactly the way any attorney who had looked at the property file for 5 minutes would have told you it would go. That was not the difficult part. The difficult part was what the court hearing revealed about the years before it, about what a family can hold in its silence and what it cannot, about what assumptions people make when they do not ask direct questions and why they do not ask them. I thought about all of it sitting at that kitchen table. Then I got up and I made a phone call to a realtor I trusted, a woman named Gwen Lattimore who had 20 years in the Decatur market and who had known my mother, and I asked her to walk the property with me and tell me what she thought it would sell for in the current market. Because it was time. Not because of what happened, not exactly, but because the house had been waiting for a decision for a long time, and I was finally in a place where I could make it. The grief was there and the weight was gone, and in the space between those two things there was room to think about what the house should become and what I should do with what it represented. Gwen walked the property with me on a Saturday afternoon. She said the bones were excellent. She said the location was strong. She said with updates to the kitchen and the primary bath and some work in the yard, we were looking at a number that was significantly higher than I had estimated even a year ago. I said, when should we list? She said, spring. She said, give me 60 days and we'll have it ready. I said, okay. I want to tell you what I decided about the proceeds, because I know that is the question that is sitting in your mind. After the costs of the renovation, the realtor commission, and the property taxes owed on the capital gain, there was a sum of money left. A substantial sum. I thought about it for a long time. I thought about the conversation I had not had 15 years ago and all the reasons I had not had it. I called Keith. I did not call Deanna, not then. That call would come later, when I was ready for it, when enough time had passed that I could have it from a place of clarity rather than from a place of residual hurt. The call I made to Keith was not about healing anything. It was about something more practical than healing. I said, Keith, when the house sells, I'm going to put some of the proceeds in a trust for Mama's grandchildren. I said, that includes any children Keith might have in the future, and it includes Deanna's children, not Raymond's children from his prior relationship, but any children that belong to the Sutton family. Keith was quiet for a long time. Then he said, you don't have to do that. I said, I know. He said, Vera. I said, I know what Deanna did, Keith. I'm not doing this for her. I'm doing it because the house belonged to Mama, and Mama would have wanted something to go forward. He said, yeah. He said it without any of the evasion that usually sits inside his yeah. He said it plainly. I said, okay. I'll have my estate attorney draft the instrument. You'll be a named trustee. He said, me? I said, you need something to be responsible for. This is a good thing to be responsible for. He laughed. It was a small laugh, surprised and a little unwilling, the laugh of a person who has been given something when they expected to be given nothing. I said, tell Deanna when you think it's time. Not now. When it's time. He said, okay. That was the call. People ask me sometimes, since this story has become one I tell, why I didn't simply tell them years ago. Why I kept the deed quiet. Why I let the assumption sit in the family for 15 years like a thing that might eventually resolve itself. I understand the question. I have asked it myself. The answer is not simple, but it is honest, and I would rather give you the honest answer than the one that makes me look wiser than I was. I was tired. I was a 31-year-old attorney paying a mortgage alone, managing a parent's care alone, navigating a career that required everything I had during the day and still called on me in the evenings and on weekends, and the idea of also managing the family conversation about who the house belonged to felt, in that season of my life, like one burden more than I could carry with any grace. So I carried the deed instead. I carried it quietly. I told myself I would have the conversation eventually, and eventually kept not arriving, and then my mother passed and the moment felt wrong. And then years went by and the silence had its own weight, and disturbing it required a kind of energy I kept deciding I did not have. I am not telling you this so you will feel sorry for me. I am telling you this because I want you to understand the actual texture of what happened, not the simplified version in which I was the wise woman who planned everything carefully and waited for the right moment to reveal her hand. The truth is more human than that. The truth is that I made a decision under exhaustion in 2008, and then I continued making that decision for 15 years because reversing it always seemed harder than continuing it, until the day my sister changed the locks and made it impossible to continue anything at all. The house sold in May. Gwen was right about the number. It was considerably more than I had expected even with her earlier estimate, because the week we listed, 2 comparable properties in the neighborhood received multiple offers and the market responded in a way that Gwen described as a gift and I described as good timing. The closing took 4 weeks. I sat at another table, a closing table at a title company, and I signed documents transferring ownership of a property that had been in my family since 1978. I signed them with the precision of a real property attorney who has sat at dozens of closing tables and knows exactly what each document represents, and also with the weight of a daughter who had bought her mother 4 more years in that house by putting her name on a deed when no one else had the means to do it. I cried in the car afterward. Not hard, not for a long time, but genuinely, the way you cry when something is over that needed to be over and you are grateful and grieved simultaneously. I sat in the parking lot of the title company and I let it be what it was. Then I called Gwen and told her thank you and drove home. The trust was established in June, with Keith as co-trustee. The instrument is structured so that it matures when any qualifying grandchild of Harriet Sutton reaches the age of 25, at which point they receive a distribution for the purpose of education or property purchase. I chose those purposes deliberately. I chose education because my mother was a school administrator and believed in it the way some people believe in faith. I chose property because I understand now, in a way I did not fully understand when I was 31, how much a piece of property can mean to a family and how much it can cost when it is not handled carefully. Keith calls me twice a month now. This is new. Before all of this, we spoke 3 or 4 times a year, the calls driven by obligation or occasion rather than by any genuine desire to maintain the connection. I do not know exactly what shifted in him when the house was sold and the trust was established, but something did. He says things now that he did not say before. He asks how I am doing in a way that expects an answer. He told me last month that he had dinner with Deanna and that she had said my name without anger, which he reported as significant progress and which I accepted in that spirit. Deanna and I have not spoken directly since the hearing. Not because I have made a decision to cut her off, but because the timing has not been right and I am still learning how to hold the complexity of what she did alongside the complexity of who she is, which is a person I have known for 43 years who did a thing I would not have predicted from her even given everything I know about her and everything I know about what financial fear does to people. I am not ready yet. That is the honest answer. I will be ready at some point, and when I am, I will make the call. I want to tell you one more thing before I finish, because I think it is the most important thing and I have been working up to it for the length of this story. When Deanna opened the door that day and I said this is my house and she said Mama's house and I said no, my house, my name is on the deed, what I was doing in that moment was not threatening her. I was not being cruel. I was not trying to demonstrate anything about power or about who had the law degree or about who had spent the last 15 years managing a piece of property while someone else assumed it would be available to them when they needed it. I was saying a true thing. My name was on the deed. The deed was accurate. The deed told the truth about who had done the work and who had taken on the risk and who had quietly carried a thing that no one else in the family had been positioned or willing to carry. The deed reflected the reality. I had simply never announced the reality, and when Deanna moved in she assumed the absence of an announcement was the same as the absence of an owner. It was not. I am a real property attorney. I have spent my career working in the space between what people assume and what the legal record actually says. I have spent 17 years telling clients that assumptions are not instruments, that feelings are not deeds, that the story of family tells itself about who owns what is not the same as the chain of title. I have said those things to hundreds of people. I did not imagine that one day I would need to say them about myself. But when I did, I was ready. When it came to the moment where the assumption met the record, I was the person in that room who understood both of those things fully, and I was the person who held the document that resolved the conflict between them. I held the deed. The deed was mine. And what the deed meant, underneath the legal language and the notarized signatures and the county recording stamp, was that I had done something real for my family even when the family did not know I was doing it, and that something real cannot be taken from you simply because the people who benefited from it never understood it was there. The house is someone else's now. There is a family living in it, a young couple who fell in love with the backyard and who are expecting their first child and who will raise that child in the room where my brother slept and will put their memories into the walls where my mother's memories were. I am glad about that. I think a house should be lived in by people who love it. I think a house should go forward. I am going forward too. I am still practicing. I took on 3 new property clients in the months following the hearing, 2 of whom came to me through people who had heard about the case in the way that news moves through professional networks, quietly and with the specific weight of a story that people find instructive. I do not discuss my personal case with clients. But I understand now, in a way I understood professionally but not personally before, what it means to stand in a room with a piece of paper that says what is true and to have to defend the truth to people who have decided that what is true is negotiable. It is not negotiable. It was never negotiable. If this story found you tonight because you are living inside something that resembles it, because someone in your family has decided that what belongs to you is available to them, because someone has looked at your silence and mistaken it for surrender, because someone has changed a lock or made a representation or begun a process they believe you cannot stop, I want you to hear me when I say, the record exists. Whatever the record shows, it is there. And if the record shows what mine showed, that you have been the one doing the real work, the one putting your name on the real instruments, the one building the real thing while others built only assumptions, then there is a process. There are people who know the process. There are forms and filings and hearing dates and a courtroom where a judge with a certified deed in her hand will say what is true. Go find those people. Go find that process. And do not mistake your own silence for the absence of a case. The house was always mine. I always knew it. I was just waiting for the right time to say so. If you have walked through something like this, or if you know someone who has, I want to hear from you in the comments below. This community exists because these stories need to be told, and because the people who have lived through them deserve to know they are not alone. Subscribe if this is your first time here, and stay close, because the next story is coming, and it is one I have been waiting to tell for a long time.